Friends, today we will discuss the concept of ex parte temporary injunction granted by the courts. In civil cases, we usually notice that the court grants temporary injunction and thereafter the problem of defendant starts as the plaintiff take every step to delay the proceedings of the court so that he can enjoy the fruits of temporary injunction granted in his favor. Keeping in view these things, the Supreme Court as well as various high courts have held that normally a temporary injunction should not be granted by the courts ex parte. Notice should be given to the defendants to come before the court and argue on the point of granting or non-granting the temporary injunction. Today we are discussing how a party can seek temporary injunction, and if a temporary injunction has been granted ex parte, what are the remedies available to the defendant. Whenever a plaintiff is aggrieved by the action or inaction of the defendant, causing loss or irreparable loss to the property, reputation, and other valuable things of the plaintiff, he can go to the court and file a suit. Along with the suit, an application under Order 39, Rule 1 and 2 is being filed for obtaining the order of injunction against the defendants. Now, the question arises whether on the basis of that application, the court on the very first date, without hearing the other party, without hearing the defendants, should grant an ex parte injunction in favor of the plaintiff, or the court should insist upon that let the defendant should come and submit their version before the court so that court can decide on the basis of merit whether plaintiff is entitled for injunction or not entitled. The law is very clear. If court is satisfied that there is a strong prima facie case in favor of the plaintiff, and if an ex parte injunction is not granted, the entire suit of the plaintiff may become infructuous and there remains no point of deciding the case thereafter. In such situations, the court may grant an ex parte injunction in favor of the plaintiff. At this stage, it is very important to understand that if an ex parte injunction is granted, what are the remedies available to the defendant. The moment summons reaches to the defendant and defendant appears before the court, and if the defendant is satisfied that the plaintiff has obtained the injunction order by misrepresenting the facts or by concealing the material facts from the honorable court, then the defendant has a right to file an application under Order 39, Rule 4 CPC for modifying or varying the ex parte injunction order. At the same time, it is the mandate of Order 39, Rule 3A that an ex parte injunction so granted should be heard and decided on merit within a period of 30 days. But as a matter of practice, we have seen that sometimes time is going on, and the plaintiff is getting dates after dates with the sole object to enjoy the ex parte injunction. In such situations, the Supreme Court as well as the Honorable High Court has taken a strong view. In Venkat Sabwaya Naidu case, the Supreme Court has gone to the extent of holding that in such case, the district judge can treat the interlocutory order of ex parte injunction as an order which is revisionable, which can be revised by the district judge or by the High Court under the revisional jurisdiction. In such cases, the district judge can even make adverse entries in the ACR of the concerned judicial officer if he or she deliberately failed to decide the application under Order 39 Rule 1 and 2 within the prescribed period. The moment defendant appeared and defendant insists upon for adjudicating the application, then it is the primary duty of the concerned court to decide the application on merit. Otherwise, the higher courts have taken a strong view of the matter in such situations. The courts have even said that once the written statement is filed or objection to the application under 39(1) and 2 are filed, the court is duty bound to decide the application on merit, leaving apart all other dilatory tactics adopted by the plaintiff. So, it is the golden rule laid down by the legislation and interpreted by the various courts that in special circumstances the court may grant ex parte injunction, but that requires to be adjudicated on merit the moment defendant press the written submissions and submit before the court that the injunction has been obtained by misrepresentation or concealment of material facts or in violation of the law laid down by the courts.